start. I'm Don Elliott with Clarion Associates. This is a meeting of the subcommittee appointed to look at interim products in the development code, the new development code for Lake Havasu City. As those of you who've been involved in the process know, this is, I'm going to turn so I can look at the human beings if I can. Can I do that? All right. Good. I'm okay. We divided this work from the very start into 3 modules. And then as each one has been prepared, we've come and explained it and tried to highlight the changes that are made. This is a meeting to discuss the 3rd module, so that now there is a full set of proposed regulations and footnotes. In some cases, we have highlighted that the decisions we made in the 3rd module will require changes to the 1st and 2nd. The way we set the project up, that's what we do next, is to go back and try to make sure that the feedback we get in the later modules is integrated and consistent throughout. Let me just go through a brief presentation about the project as a whole. There are mostly familiar faces here, so I will go through the background quickly, and then highlights from the different parts of Module 3 and what is being proposed to be changed. As most of you know, this is a 2-part project in which our firm, Clarion Associates, has been hired to update the general plan for Lake Havasu City, which is required by Arizona law and is required to contain some new elements because at the time the measurement was made, the city is over 50,000 people. We've had some publics say they think it's under that now, but according to state law, it was over at the time the measurement's made. It probably will be over in the future. And therefore, new elements have to be added. When you're over 50,000, new things have to be addressed, things like circulation and connectivity, and some things in more detail. I'm not here to discuss that general plan. We'll talk about when that's coming to City Council. That's been about a year in the making, and it's near the end of that process. We're going to talk about the development code. So we'll talk about an overview, highlights of Module 3, the next steps, and then just take questions. Once again, general plan update and development code update. We divided it, first of all, into scoping and direction, and I've had some questions about where we got that direction. When we began this process, we looked at all the background documents and the existing codes and regulations, and when we sat down for a series of, I think, 2.5-day meeting of 4 or 5 groups each day to talk to stakeholders about what they wanted to see. That was step 1. Step 2, at the time we started this, there were some questions about how the city should enforce the code. So we did a little background paper, which was taken forward by staff without us being here, to talk about that with City Council. And that's just an interim product that was prepared. 3 was to evaluate the development code. Where does it not line up with some of the goals in the old plan or the emerging new plan, and to try to simplify it. Then we divided we put a staff draft and a public draft of each module, 1 and then 2 and then 3, and now we're at the end. We're at the end of that step 4 and 5 with what is left to do is refinement and adoption of the code. I'll just go through this briefly. If you look at the colors, the green was in Module 1, which was last fall. That was basically procedural. How does the city do business of administering the code? There was ambiguity in what's going on there. There were differences from best practices around the country. So that came out last fall. Module 2 was zoning districts and permitted uses. One of the themes from the very first time we interviewed with the city for this job was that the current set of zone districts is very confusing, particularly those that came out of the RUDAT, Regional Urban Design Action Team process a few years ago. We heard in the initial comments that people liked that for downtown, Southgate, other areas. We heard it from many people, but we also heard that no one had built under some of the emerging zone districts because they were so complex and because their relationship to the underlying zoning was very unclear, and we agree with that. Module 3 today is everything except zone districts and what you can do on the property. It's form and development controls, meaning how big can it be? How much parking is required? Landscaping, lighting, neighborhood protection, which is a new element to try to protect single-family neighborhoods from whatever happens next to them that may be higher or more dense. We call this quality. How good does it have to be, not what can I do with my property? So there's a lot of content in here. Let's talk about the highlights. Darcy White is the member of our firm who's led the general plan update. She's about 3 doors down from me at the firm. And so we have tried to align what we're doing with the comp plan update. That's, I think, why the city hired our firm to do both of them. We have, over time, as the general plan update has gone along, discovered that some of our thinking in the code needs to change, because the point of the code is to align with the general plan. It's not only a good idea, it's the law. And as the general plan update has gone in certain directions, we need to make sure that the code does it. So aligning that, the menu of zone districts, which I mentioned a minute ago, has changed significantly from the current code. Well, when you do parking, when you do landscaping, when you do dimensional standards, how tall, how dense, how many setbacks, those have to align with the new menu of zone districts. So that's another point of Module 3. I've mentioned that RUDAT, it has been endorsed when we started this process, particularly for Upper McCullough, where we are now, and for the commercial health district, the lower McCullough area, some of the Channel Riverwalk area, and Southgate. Those are the 4 areas that we're really focused. Those are the areas for which the RUDAT developed controls, which we say are too complicated, but whether they are or not, nobody has built under, because nothing's, partly the recession, partly their operation is really unclear. But we heard several times, we like the vision of RUDAT for those areas. We just got to make it work. So that's been part of our marching orders. As I mentioned earlier, current code has no standards that kind of kick in automatically to protect lower density neighborhoods from what happened next to them. We wanted to add that. And then there have been changes in both Arizona law and federal law that we needed to align with, particularly in areas like group homes and medical marijuana. Some of you know there's a new sign code case out of the Supreme Court, which we have not reflected because it came out last week. But that's the kind of thing we've been trying to do. So what's in Module 3? Well, it's a long list. It's dimensional standards, meaning how tall and big, parking, access and circulation. That, by the way, is driven partly because every code has something on how do you lay out the lots so people can get to them and how do they circulate, partly because the new general plan update for a city of more than 50,000 has to address that in more depth, and not just for automobiles. It's very clear that for smaller cities, you're kind of supposed to look at all modes. For larger cities, you're supposed to look at them more seriously. So there's a section on access and circulation. Landscaping, screening, outdoor lighting, neighborhood protection, site and building design. Number of things in the form-based districts that came out of the RUDAT talk about making the buildings look good. Some of those we thought were too complex and too highly detailed, and were part of the reason people weren't attracted to those districts, and you haven't seen much investment along these areas. And part of it is simply, in most new codes, those types of controls are not just for the downtown area. They're for all the commercial areas, or they're for all the multifamily areas. So we were taking some ideas that came out of the RUDAT, applying them primarily in these 3 commercial areas, but also saying in some cases those are just general good practices. And I should just say that in addition to reflecting the rules of the RUDAT, we were asked to reflect best practices from our work around the country. I know that some people have disagreed with our judgment on that, and that's why we're having this process. But we were asked to reflect what other cities of this range, particularly in the West, particularly with dry climates, would do in these areas. And so it is not true that everything is driven by the RUDAT. In many cases, it is clarion, saying cities your size do the following. And we recommend it or we don't. So, and then signs and operation and maintenance. Operation and maintenance meaning once you're approved to build it this way, you need to maintain it that way. If it dies, you got to replace it. If you come in here and decide you're going to take the lighting out and put in new lighting, it still has to meet the code. So that's that section. Let's talk quickly about dimensional standards. I'm going to highlight a few things in here that are, I think, key. Here, and in each case, there are 3 tables that summarize all the information in the current codes about setbacks, lot coverage, density, height. One for residential districts, one for mixed-use districts, which contain a blend of residential and commercial, and one for special purpose districts. And that's kind of the emerging standard way cities do their codes. At least almost all the codes that are being written today try to group the districts into those kinds of categories. And so I'm showing you the first few lines, not the whole table, the first few lines of each of the 3 tables, and I'll highlight some of the key changes. Those of you who've looked at the document know there are lots of footnotes. And that's because we have tried to indicate where this will change people's rights. I know it's hard to read. When we get to council, our recommendation will be you get rid of those footnotes because they make the thing hard to read. But until we get to council, we need to have a way to say this is a change or it is not a change from what we had, and why did you do this change? There are also some footnotes that say we're going in this direction, and then the second sentence says, well, upon public reflection, we're not going in that direction. We're going back the other way. So the footnotes are important. They can't be done without. They will not be there in the final code. They're just explanatory. We have tried to write it so that when we get to that final stage, we can give you a copy of this that has none of the footnotes in it. Now, I imagine the city attorney and staff will want to keep their copy because it answers a lot of questions. What did this used to be? Why did they change it? But you don't need to have that in the adopted code. And when we take those out, it's going to be a shorter document and I think a lot less difficult for the public to read. But here is the first few lines of the residential districts tables. I want to point out that we had grouped in our earlier drafts R3, and we said R2 district and R3 should be merged. That resulted in a number of complaints from people saying we don't want that to happen. And upon reflection, we've agreed. So R3 is not going to happen. We're going to keep R2 and R3 as they are in the current code. Second issue was that over here in your residential agricultural district, that the code actually says that can be 1 or 2 dwelling units, but we had public feedback that regardless of what it says, people expect there to one DU per acre, not 2. And that's what it has been developed at. It's your lowest density zone district. It should be 1, notwithstanding the fact that the current code says 1 to 2. So that says 1 now. When we looked at R2 and R3, there were different versions of the code that were being read. And R2 actually said that its density range was 4 to 10. Well, as outside consultants looking at that, we said these are pretty similar. We can look at the districts. It turns out that that was probably a mistake in the way the current code is drafted. So when we divide R2 and R3, when we leave them the way they are in the current code, we will straighten that out and say it's not 4 to 10, it's 4 to 6. And that's been staff going back to say, how did this happen? Did we mean 4 to 10? Why did it say 4 to 10? No, we don't think it meant 4 to 10. So that is part of what will happen as we don't merge R2 and R3. This I wanted to highlight just because this is where we start talking root at. The left-hand image is kind of the zone districts that emerged out of the root at. When you try to map them, and many of you know, one of the problems was after RUDAT was written and the zone districts were added to the code, some, but not all, of the land that it was affected was rezoned. Matter of fact, most of it wasn't rezoned. So you had these districts on the books with maps like this in the book saying this applies to this area, but the actual zoning map had not been amended to change the base zoning and to say either this replaces it or it supplements it or what. That was part of the confusion. So this was, I think everybody will admit, on the left, a pretty complicated and I would say, micro-designed approach to this. On the right is a simplified approach that we have tried to put in to say, look, the guts, the DNA, as it relates to Upper McCullough for our RUDAT was walkable, yes. Mixed use, yes. That is where some of the taller buildings would be. It's supposed to be multimodal. It's supposed to be your walkable downtown as opposed to Lower McCullough and other areas. You don't have to have a map like the one on the left to get that result. You need more density and closer to the street right along McCullough. You kind of need a second tier along Mesquite and the secondary streets, and then you need tapering down to the neighborhoods behind it. That is a much more intelligible translation of the idea behind the RUDAT into a zone district. So that's what we were trying to do. Here is a portion of the dimensional standards for the mixed-use districts. And I just want to point out that this is a lot of what's going on here. We were trying to sort out, for example, MUUMS is Upper McCullough, mixed-use Upper McCullough. And there were 3 different sub-areas for that. Same thing happened in Channel Riverwalk. But a lot of the action we've been doing is to try to sort this out. Another change from what we said earlier. Our first draft said in the mixed-use neighborhood, that's a small scale, not Upper McCullough. This is a small-scale, mixed-use, community-serving commercial. Convenience commercial so that people don't have to drive so far to get what they need on a daily basis. That is a new zone district, and it consolidates some of the ideas behind your current CN, CO, and CR. This is an area where we're not talking out of the RUDAT here. This is Clarion saying almost all new codes for big cities, citizens want something that is not, that they don't have to drive to the mall to get everyday goods and convenience goods. You need a district which does that, and there's no reason why it can't have a mix of residential and commercial. So this is not RUDAT talking. This is Clarion saying this is a pretty common thing for big cities to do to try to get at these issues of convenience and driving trips. CR is a weird zone district that only applies to one parcel of land out on the island. And after talking it through in public meetings, we're not going to roll that into it. It turns out that CR is just a blend of this part's commercial and this part's residential. So we're not going to carry it forward. It's only one parcel. And when we bring it to the end, the commercial stuff will be put into a mixed-use district. The residential will be put into a residential district. And you don't need this particular district. That's what the arrow indicates, is that was a one-off that we can not have to carry forward. I do want to point out down at the bottom, I mentioned that footnotes will go away, and they will, all 1,000 of them, or however many hundreds there are. There are these things in brackets which are table notes, which try to simplify the tables by telling you whether there's a separate rule about something. And I want to point out that in our effort to try to simplify the RUDAT stuff, we left the heights near McCullough, where they were, and then taper them down, as I said. But there are, you can see that this is how it happens. Heights are limited to, that bracket 2, I can hardly read it up here. The real limit there is 60 feet. It blends two zone districts, one of which was 36 feet and one of which was 60 feet. We left it at 60 feet, and then we said heights are limited to 42 feet on sites adjacent to or across the street from. So as you taper and get around from this district, they drop to 42 feet. It's not the 36 feet that was there before, but the lines don't line up. And then, if you are happen to be adjacent to a 1 or 2 family neighborhood, they drop to 18 feet. We get that from the top. Dimensions may be modified by the neighborhood protection standards in 14406. I'll talk about that more as we go through. But basically, we consolidated. We did not take the lower of the heights. We did not, and we left it at the higher of the 2 heights because we don't want to make properties non-conforming. And then we said, as you move away from McCullough, they drop to 42 feet. As you move it next to single-family districts, they drop to 18 feet. The height number 3 is a similar thing for parking structures, and it also says you're dropping to 20 feet as you get away from McCullough. So is it exactly the RUDAT? No. We were paid to try to make it simpler. We think this is a lot simpler that carries forward the idea of tiering the density down. The third table I want to show you is this one, special districts. And I did want to point out a couple of things. One of the things we tried to do and were unsuccessful for, this happens every time. You try to simplify, and after a while, once in a while get into something and say, that's too much simplification. And that's what happened in the conservation preservation zone district. We were trying to consolidate 4 districts up there, 4 of your current districts. And it got really awkward and messy. And for one thing, people like the use of the term agriculture, so we agreed at the last round of meetings that this would not be called CP, it would be called ag for that. But we are now proposing that when we roll in your public comments, this will be divided into a more open space like you have now, the ag district and the conservation preservation, which mostly covers the state-owned lands around the north and the east side, south of the city to the highway. That's what we're talking about. Body Beach and the island are 2 others that also affect, in some areas, state lands, but are really of a different character. So although we tried to merge them in the interest of simplicity, we have decided that can't be done, and we will be dividing those out so that they're 2, rather, there won't be 4 districts, but there will be 2, one representing the more tourist character of Body Beach and the island, and one representing the more open space character of the ag and conservation lands. So that's an area where we're going back rather than forward. There you go. That circle is an illustration of how trying to blend these was getting awkward. So that's dimensions. We can talk about more if you'd like. Parking and loading. this is another area where we're not talking Rudat, we're talking Clarion. Almost every city, a matter of fact, every large city that we work with asks us to review the parking standards. How much parking must we have at different types of development? And to look at it and not require more than others do. Now, we can amend this. I know that there's always people in the neighborhood or the city who think, we got too little parking, I can't find a parking space. So we can up these, but what we've put in the code is a table that compares what you've got now with what other cities of this size are doing. We also try to simplify them. There's some things that were old practices that turn out to be really hard to do. For example, parking standards that say 1 per employee. Well, the number of employees changes. It might change monthly. At a minimum, you can say the design, how many people it's designed to occupy. Same thing happens with schools and other things. But you try to come up wherever possible with a standard that says it's based on the gross square footage of the building. That way staff can interpret it, the developer knows it, the neighbors know it. Everybody can tell a building this size of this type has this many parking spaces, not something where, well, we designed it for this many employees, but now it turns out there are more employees. So we've tried to simplify those. There's a table over here on shared parking reduction, another best practices from around the country. When you get a combination of residential and institutional, or residential and restaurant and entertainment kind of uses, or retail, the total parking needed is never the sum of the individual parts. It is always a lower number than the sum of those parts. And this table says, when you have the following combination, add up how many you'd require for the residential and how many you'd require for this other use, and divide it by the following number. Because it's never additive. As a matter of fact, I've never seen a modern code that makes it additive. The current code allows it, but kind of says, the director can decide. We think this is a much more objective way of going at it. Bicycle standards, once again, I've heard outside of the meetings, some people really don't think they're appropriate for Lake Havasu City. It's a hot city. Today's a hot day, and not many people are riding bikes. The comp plan and the circulation element talk about multimodal transportation. That's a matter of Arizona law. We can change them, and I invite comments. If you want to say we don't require any bicycle parking, that's fine. But it is one of the traditional ways that people try to implement multimodal access and transportation, and one of the ways you try to reduce the length of car trips and vehicle emissions by saying, well, yes, it's hot in the summer, it's not hot all year round, and if you could ride a bike more in the winter, you wouldn't have to drive as far. So that's part of what we've done. Now, we have exempted some of the smaller parcels. When you have a parcel of 5,000 square feet or less, we say, some cities say 10,000 or less, it's really hard sometimes to develop that parcel with a use, particularly a multifamily or a commercial use, and get parking on the site. So when you say, even if you have a small site, you need the following amounts of parking, you create a Hobson's choice. Either the property doesn't get developed because the guy can't get the parking on the site as well as the store or the facility, or they buy the facility next door and have to acquire land in order to do it. That's okay if it's raw land. If it's in an established commercial area, you wind up having people buying buildings and tearing them down to provide parking for the new building. Most cities say, that's a bad result. That's not what we intended to do here. So we have recommended exempting small lots from the parking standards and saying it's just not needed. But small lots that are more than a distance from residential, we said 100 feet. Maybe it's 300 feet. We'd be happy to have comments. Once again, parking in common, truly unique part of Lake Havasu City, coming from Mr. McCullough and his vision. Lots of ambiguity as how they work and what you can do. We've just tried to clear it up. There is no silver bullet. These are legal contracts that people have entered into, and they have attached them to their property, and Don Elliott can't wave his wand and fix this problem. These are property rights. But what we have done is clarify that A, they're binding. We've put a place to list the effective ones, the ones that are still effective, and what properties that they affect, which is part of transparency. A property owner or buyer can read the code and say, well, I guess my property is subject to a parking in common agreement. I better go read it. It does clarify that you will not be able to mark off your part of a parking in common area. If that's a contract, guys. It's attached to your property. But it also says if you need a variance, you can use the variance process to try to modify it from the point of view of the city. and it includes the standards that will be applied when that comes forward. It's not a traditional variance hardship standard. It is sort of a, how is this going to make the nearby properties that are also part of parking in common unusable or make it difficult for them to use their properties? So it is an imperfect solution to a very difficult problem, but it is addressed in the code. You have a parking in lieu fee provision for the Rudat area, which has never been used, and so we took it out. You can add it again if you want, or we can leave it in, but nobody's used it. Parking in lieu fees are difficult. They sound great, but once you collect the fees, you got to spend them on something to build the parking, and if you're not getting much development, the city can wind up holding money that is too little to do anything with, and then they're pretty much obligated to refund it because you can't take money for no reason, so we took it out. There's illustrations about drive-through standards, which have been simplified. Off-street loading standards have been tried to be simplified. And once again, this is important. There was a provision on can you park your RV on your property that it said, yes, you can, and you can have a third party park it for more than 30 days, for up to 30 days. We have recommended that came out, that came from staff saying that we needed to take that out. Everything having to do with what you can park on your property is going to be controversial. No matter, if you leave it in, you'll have people say it ought to come out. If you put it in, if you take it out, they'll say you ought to put it in. But I'm calling your attention to the fact that the draft says that. Access and connectivity, once again, because that is one of the new elements that has to be addressed in the general plan. Sidewalk standards have been expanded. We heard in our initial comments that people wanted more sidewalks and more ability to walk around the city without having to walk in the streets. So the minimum widths have been expanded, and the types of properties to which it applies. But again, this doesn't apply retroactively. It means in the future, as people come forward for development, these standards would apply. You had a standard that multifamily has to have walkways between buildings. That has been expanded also so that any multi-building development on the same property needs to have internal walkways. And then vision clearance, this triangle issue of can you plant landscaping or do a fence close to the property line, or how far back do you have to stay at? We've tried to illustrate it and clarify how that operates. Landscaping and screening, once again, to be honest, a weak part of your code. We heard when we did our initial interviews with people that they liked greenery. Obviously, it's a desert climate. Obviously, not much grows easily. And yet, we heard nobody said we shouldn't be requiring landscaping. They said, particularly along commercial streets and along commercial development, we'd like more. We'd like to look better than we are now. So we've tried to establish some. Once again, single family and two families are exempt. If you build a house or a duplex, you do not need to read the landscaping section. Some cities do, but I'd say less than 10% because it gets really politically difficult, and most people don't want the city calling them up and telling them that their lot needs more landscaping. So you just exempt them. Say a woman's home is her castle, and she can plant or not plant as she feels like it, but multifamily, mixed use, other things need to follow this code. If you're under 10,000 square foot, same argument as parking. You're going to have a hard time doing building and parking and landscaping, so we have exempted small lots. And we've said if you have an existing parcel without landscaping or with very little, you don't need to read this unless you're expanding your building by more than 25%. Every code has to have a trigger. We know that current stuff doesn't have to comply because they've already built it. We know that new stuff has to comply. What about expansions of existing buildings? And so you find a number. Some say 15%, some say 20%. This is about as high a number. We've said 25%. You can expand your store by 25%, your building, and you don't have to comply, but you do it beyond that, and you will have to comply. Landscaping requirements can get really hard to understand. We think they're easiest if you say, look, there's only three things going, Only three things going on here. The street frontage in commercial and multifamily areas needs to be landscaping, street trees, things that improve the appearance. Parking areas, almost everybody wants parking areas to have some landscaping in them. And then edge buffers that only apply if you are different from what's happening next to you. So, as I've said at prior meetings, Taco Bell does not need to be buffered from Arby's. They're the same thing, no offense. It's the same use. Multifamily doesn't have to be buffered from multifamily. There's no difference in impact. But commercial from multifamily, multifamily from single family, industrial from other things, those are buffers that ought to kick in automatically and not be negotiated each time. And so we've tried to organize it into those three categories. We've tried to be clearer about when you have to screen your equipment ground-mounted equipment or service areas, dumpster areas, loading areas. And we have put in a provision that the director can approve alternatives within certain boundaries. I believe this is a best practice. Almost every code we write puts this in there. Once in a while, people are very nervous about this, and that may be true here. However, you know, you're trying to fit buildings onto sites. You're trying to fit parking onto sites. You're trying to make them contextual with the fact the site may be sloping, and it may be that trees here don't make any sense because nobody would see them. So most new codes say, look, that's part of a planner's job to try to fit this development onto the site. The director may approve variations and alternatives. If the director decides this is just as good at visual screening, at buffering the impacts as to what is proposed, that doesn't have to go for a variance. That is within a defined ambit of judgment that the planning director can do. And we can talk about that. I think some people are nervous. Exterior lighting, mostly carried over. We did include new light pole standards, and we did kind of make a general requirement for full cutoff light fixtures. Lighting is not rocket science, guys. It's how tall is the light, and is it spreading the light everywhere or focusing it? Almost every new code has these provisions. Neighborhood protection standards. This is, once again, something that many new codes have, which say, look, for historical reasons or whatever, we sometimes wind up with industrial next to single family, or just a pretty dense commercial zone next to single family. It happens. It happens in every large city for whatever reason. How do you make sure that future development in those intense areas protects the low density, particularly single family and two family development next door? And our approach is to say certain things happen automatically, and here's what they happen. It applies to all lots in R3 or RM, or multifamily, with buildings, all lots in an area where you are developing next to a single or two family home. So you're in a zone district that allows multifamily, but for whatever historic reason, most of them are single family and two family homes, but it's zoned to allow an apartment. This applies to those situations. If an apartment were to come in, it would have to protect the single and two family homes in the following ways. And then all lots in a non-residential district that share a lot line with a residential district, lots with one or two family homes. Building height has to come down to 30 feet. And actually, I'm wrong about that. That's a typo. It's 18 feet in most of these districts. So it's 18 feet. 30 feet is often what cities decide on, but you have a lot of single-family, single-story homes. And so the idea is, within 100 feet of the lot line, that building can be taller, but within 100 feet of the lot line, it needs to come down to the height of a single-story house. Light poles, same thing. That's 18 feet. I put the 20 feet in there. Increasing setbacks. Whatever the setback was that your building had from that property containing a one or two family development, add 10 feet to it. Landscaping needs to be installed. I mentioned the buffers kick in. Well, this is just saying if you're doing a fence, one of the options is through a fence. You got to put the landscaping on the single family or two family side of the fence. They should get the benefit of the greenery that helps buffer the wall or the fence. Now, you can put it on your side too. That's up to you. But the required stuff has to be put so that it mitigates the impact on them. And then it currently says no drive-through or circulation lanes between the home and the commercial or the multifamily. These are all out there for your consideration. The idea is to say you don't have to negotiate these each time. These kick in automatically. It's mostly heights, circulation, and buffering. Site and building design, I mentioned this comes out of some of the RUDAT ideas in terms of how you make sure you don't get buildings that are really substandard. But again, single and two family homes are exempt. There is no design review, design standards for those homes, and heavy industrial is exempt. They address, in general terms, materials, and it doesn't specify them. It says durable, high quality, and colors. Those are carryovers. So this is a case in which it was mentioned in RUDAT. It was not mentioned in the rest of the city. Many Western cities that are redoing their codes say things like this. So this is Clarion talking, and this is an area where the RUDAT idea has been recommended for broader approval through the city. Entries and sidewalks, just meaning getting good ways to get people into the front of the building and emphasizing the entrance. And then if you have building walls more than 100 feet long, they have to articulate horizontally or vertically just to avoid the wall canyon. In fact, once again, heavy industrial is exempt from that. Last slide, basically. Signs we have carried over largely. We have not reviewed these against last week's case of Reed v. Gilbert. I will tell you, I think it's going to require some changes to your sign code. We hadn't anticipated that, and 90% of the countries in the city are doing the same thing you're doing, saying, I think we're going to have to rewrite our sign code. It's really strict as to how you can name different types of signs. So that has, I want to be clear, we hadn't anticipated doing that. We advised the city going in that it's best not to mix sign arguments with the rest of the code. It's hard enough to get a new code in place that works well and reflects the plan without getting into a signage argument. So we made an agreement early on that we'd try to carry it forward, but for bringing it into compliance with state law and federal law. And this last case last week was not anticipated by any of us, and so we have not anticipated rewriting it by Reed v. Gilbert, because that would take quite a bit of work that we hadn't anticipated. Operations and maintenance, same as what I said. If the city's approval or the code made you put it in and it dies, or it's broken, or it's fixed, you need to replace it. Now, none of this stuff is enforced by running around. If the neighbors call and say, hey, all the plants on his site have died, you now point to the code and say, look, when you put plants in and they die, you've got to replace them. So it's a complaint-based enforcement, as all zoning codes are, but it gives you a way to say, look, we didn't require this for fun. I've worked in cities where, frankly, that's the established practice. The guy puts them in, and then he lets them die because he doesn't want to deal with them over time. And the whole point of it was to have some landscaping that lived. So there we go. We'll do questions. I did want to point out the next steps for those who don't want to stay for all the questions. July 28th is a council meeting about the general plan update. Once again, I'm not involved in that. That is, Darcy White will be here to talk through that. That has been briefed along the way. I'm sure there'll be good conversation at council. And the next step in our part of this is to go listen to your input today and public input that we get related to this and that we've gotten on the first two modules, and then put out a hearing draft, capital H, capital D, meaning we have tried to get rid of the inconsistencies. We've tried to roll in the things that needed to be rolled in, the changes we made in Module 3 that have ripple effects back to Module 2 and Module 1. We've sorted those out. And it does not mean it's ready for adoption. It means it's ready for a hearing in front of planning. And then it'll go on to council. But that's, we do part 1, part 2, part 3, and then the last one is all of it together, which you have now, but you don't have it all with the changes that you've recommended along the way made. This will do our best to incorporate those comments and changes, and that will, according to our contract and the normal way of doing this, that is ready for discussion by the planning board and public testimony at that time. So I think that is it. I'll leave this up and we'll do questions. I think Laura is the one committee member here, so she can have the floor. But if you have comments and you don't already know, Stu is the project manager on this, and you're free to contact him. I don't think I've gotten any direct contact. If people contact me directly, that's fine, but I just forward it to Stu. So we deal with it, but there's no side conversations around Stu and the staff. So, yes, Laura.
Some of the issues I had questioned, I'd called Stewart. Obviously, he's spoken to you because some of those were addressed.
Good. Okay.
Here. The first one I guess I'll start with is the parking.
Okay.
It looks like, from what I could tell, it's a 40 to 50% reduction in what the current parking standards are in the code.
It's based on which use it is. Some of them have that high, and many of them don't. There's not a blanket 40% reduction in the code. Some of your standards were similar to what other cities used, and some were higher. And so there's not one number out there.
Okay, yeah, most of them I checked. It looked like it was about a...
We didn't apply a number to them.
Okay, I gotcha. Well, and the problem
Actually,
I had...
I'm glad you raised it, Laura, because if that's a pretty dramatic... If that's what you... Well, let's both check our numbers, because
okay, I will go back, because I didn't do every single one of them. Yeah. So, but the majority of them that I did check, it was like, wow, it's...
Well, we didn't make them up. We didn't apply a standard formula. What we did do is I have a document at home in the office where we keep all the parking codes we've written over the past 15 years, and we kind of look at the use and look at what other cities do, and it came from that. So.
Okay, gotcha. Well, and I'm looking at one of our parking in common.
Okay.
And most of those have that type of reduction, and that's where we seem to have issues with parking.
Okay.
So that's a concern that I have. Most of the time it's you have your parking set up and it works. It's probably overkill, which is why we reduced it some years ago. Whenever a restaurant goes in, it blows everything out the window.
Yeah.
And so if we start doing everything on this square footage, which it looks like we're going to on a lot of them, and the code did do that in some areas, are we going to have that same problem with some of the other type of uses?
Well, my draft is up there, and I can go pull it out.
Okay.
I'm almost certain it is gross square footage, but restaurants and bars are called out because they always have a higher need than anything else.
Right.
Most cities use one space per 150, 6 or 7 spaces for 1,000 square foot, and I think we've recommended the same thing. I'll be honest, some cities go down and say 1 per 100 square feet, 1 per 75 for square feet. We think that's overkill, so I think we put in 1 for 150.
Yeah, Denver downtown is horrible.
Yeah.
Areas in California are terrible, and you end up paying $20 to park. Do we want Havasu to end up like that?
Yeah.
I don't think so. I don't like if we take away the responsibility of some of the parking from the developer, they're going to force the people parking out on the streets. And the prime example I always use is go down to Kiowa and Lake Havasu Avenue where Rusty's is. It's a very busy restaurant. You have cars parked up and down both sides of Kiowa, both sides of Lake Havasu Avenue. And if you live here, you don't drive through that corner.
So I think what your recommendation, Laura, is at a minimum to make sure we're doing it adequately for bars, restaurants, and retail. Are those your 3 areas of primary concern?
Yeah, and then the 5,000 square foot on the lots. I asked Stewart, how many lots are we talking about in Havasu and where are they? Because again, if you don't limit what type of development can go there, you put in a drive-through, or well, a drive-through would probably work actually, but say a small restaurant, you're going to have the same problem, and who's next to those properties?
So we could deal with that in 2 ways. One is to just take out the exemption for 5,000, or to limit the exemption, say it doesn't apply to bars or restaurants or retail if you want to.
Well, I'm just looking, if you have somebody that builds anything, they're going to need to park, so where are they parking?
Well, the reason well, yes and no. If you want, we can put in a minimum and just say, every lot's got to have 2 spaces if you want. I mean, we can just say that so that which handles it. It's not the way most codes are being written these days, but I don't have any objection to doing that.
Okay.
If that's
I
good.
would just like to know how many lots are we talking about, and
But think about this area up here. I bet a lot of the shop owners, I mean, they park behind their buildings.
Right.
Some of them don't. Some of them probably park on the street. This idea
Probably.
that everybody parks when they drive to work at their shop is pretty true, but it's not completely true.
right.
Yeah.
Most of them do.
Yeah.
That was another thing, I guess I wondered, when do you look at Havasu as its own uniqueness and not apply the industry standards? Because it seems like that's getting overlooked to a degree. What Havasu people who moved here and what they wanted to see developed and why they moved here is now being kind of sidestepped with, well, the industry standards this.
Well, we've tried to, trust me, I'm the guy who wrote these. When we go through, and I'll be honest, when we look at this and say, which of the standards that we have written around the country should apply, I look at low-density, auto-oriented cities, because that's what this is. And I think other people have made the point. Not only that, but in the summer it's hot, and even people who wouldn't walk elsewhere or wouldn't drive in another city are going to drive here because of the air conditioning. So I don't think we should go back to your current standards. I think that would be throwing money away. You've paid us to look at them. It sounds to me like the exemption is a problem. The exemption's a problem for you. Retail, bars, restaurants, and we should make sure of that. The rest of them are not, these are not Denver standards. I didn't write the Denver code. I don't have the Denver code, so.
Well, you got to agree downtown is terrible.
But downtown Denver is exempt from parking. Downtown
Oh,
Denver
is that why?
Downtown Denver is totally, there are no parking requirements in downtown
Well, you definitely don't want to do that.
No, that's right. No, but you just want to make sure, and I guess the best I can do, Laura, is to say, if you can point me to particular issues that, and you already have 4 or 5 of them,
Yeah.
I'd like to focus on those issues. I don't want to go back and review each one, because the truth is, a junior high school in Lake Havasu is about like a junior high school in Tucson.
Right.
And is about like, and we wrote the Tucson code. It's fair to compare those auto-oriented Sunbelt hot cities. And if that's not a problem, now maybe schools are a problem. I've worked in places where they really think high school parking is a problem. But pointing me to the particular uses that create the problem is helpful.
I think the only issue on a school, when you bring up schools specifically, is the one charter school where it happens to be in a parking in common area.
Right.
And that one does have some issues with the parking. To clarify a few points.
Yep.
The RA, R2, I will show you an email after this where that was an error.
The one or two dwelling.
Those two
That's
issues
fine.
we
Good.
had, just so that you have it for your record.
I'd like to.
Doesn't
That's
need
great.
to be stated.
I don't think anybody's going to complain about what we're doing there.
The land use and why some of these districts were not utilized and why we did not as a city mass rezone all of the areas. Actually, several reasons why all the areas weren't rezoned. One was some of them didn't have the correct land use.
Meaning they had A, but the RUDAT said it ought to be B.
Well, no, your general plan required that a specific designation for a mixed use.
All right.
And they didn't. They had strictly commercial or they had a residential.
Okay,
so you couldn't, and then the question I brought up at that time was, okay, are you going to have a mass land use change? What is that process? Because I've never even heard of doing that. Anyway, that kind of stopped.
Okay.
The other reason was Prop 207.
Right.
In the event we think these all look good on paper, but then they implement them.
Right.
What if this community hates them?
Yeah.
What if we look at those standards and go, this was awful? We didn't think it was going to do this. You can't change it back once you've given that zoning to what it was, because most of the time it was increasing heights, increasing density, increasing uses. So you can't suddenly turn around and go, whoops, we don't like it. We're giving you back what you had a year ago.
Well, we can, Arizona's Arizona. You've got Prop 207.
Right.
And we've tried to be sensitive to that. As I explained with the heights, we're trying to minimize the number of people who go to their lawyers and say, I think I've got a 207 claim, and the lawyer says, yeah, I think you do. But I don't know what else I don't know what to do about it. Periodically, you redo your land uses, and then you redo your code to match it. That's what we've tried to do. I would be happy to explore with the city attorney whether we try to come up with a process, an administrative process, to deal with claims of 207. For example, if you, I guess you're really worried that you can't undo it.
Well, yeah, because that's happened. They've changed things that, one council, and then something gets built and the community's like, we don't like that.
But
we don't want, so then at least you hadn't rezoned an entire area, which in the past, I guess you could have done that because you didn't have a 207 issue. So.
Well, we should talk, it's a serious issue, and I think it's inherent in doing business in Arizona. They tell you got a plan, and then they tell you your code has to match the plan, and then they tell you that you can't take property rights. And we think we have balanced that pretty well, but I think the answer to your question is going to be in a procedure to handle people who think, to figure out a way where if people are unhappy with what's been done through this change, you can modify it in ways that don't lead to a 207 challenge. I don't know what else to do. Otherwise, you can never change your zone to match your plan, and that can't be the way Arizona law is supposed to operate. So.
Right. Okay, well, and most of that was to clarify why things didn't happen and why I don't think it was as much confusion as it was that. And then also, why not go for a PD? All of these sub-districts were required actually to have a plan development. And that's where you thought this was a little bit different than any other code, which I agree, but it was to kind of compromise between the two extremes we had in the city.
Yeah.
And that was one wanted to allow all kinds of uses, all kinds of heights, leave it up to council to decide what these heights were going to be.
I don't want to brainstorm out loud. There are different ways we can try to, I will maintain my comment. Making people go through PUDs and negotiating is not the preferred way, and thanks to the Supreme Court, the line of reasoning in Kuntz, most cities are trying hard not to wind up in individualized negotiation. So I think, our recommendation is, I think, conceptually, update your plan, update your code, do a mass remapping, and figure out, and maybe it's in the process of adopting that remapping, that you get some agreements from the property owners as to what will happen, or waivers of claims, that if in fact it needs to be changed, then there's not going to be a 207 claim for anything that goes back and gives them still, no less than what they had to start off with. I'm brainstorming out loud.
Right, I got you.
But I think the answer is process, because the alternative is, if the alternative is Lake Havasu City cannot remap its city to match its new general plan, then you shouldn't have hired us.
Right.
So,
Well, and I guess the districts were hard enough for a lot of the public to swallow because of the height difference and the density difference. And it seems that you're kind of taking down some of the requirements that were in those PD sub-districts, which then the city council could approve the additional height. Because when they talk about the underlining zoning district, if this property was C1, limited to 25 feet, all commercial, and they're coming to the council to say, we want to plan development and we want to change to the Channel Riverwalk. Well, that plan that they present to the council had to show, here's why we want the added height, and here's how we've mitigated any of the issues that the people are going to have. Can we have the 60? It wasn't an outright guarantee. If you go to this zoning, you're getting 60 feet. So I guess when you take away some of these standards that were designed and now they're no longer applicable, you automatically have everything outright. That's going to be a huge change for a lot of us that were opposed to some of this.
well, what we said at the last meetings was, a PUD is a negotiation. Your current code says you can negotiate a PUD up to 90 feet. It's 60 feet in Channel Riverwalk, you can go to 90 feet.
You had to get approval for 60 feet also.
Well, no
That's
matter
the
what the
difference.
numbers are, when council approves a PUD, they can approve whatever number they want.
Right.
So what we try to do is simplify it and say, look, we've set the heights, we've done the taper down, and it is still true that if you don't like your heights in any of these districts, you're going to go in and ask for a PUD to get greater height. I think at your issue, maybe we should look at the PUD standards for council approval and for planning board recommendation and say, we need to make them tougher. Yeah, but they ran on for 20 pages, Laura. I'd never seen another code
No, I
like
understand
this.
that. The problem was we didn't have a lot of plan developments presented until they took away the acreage minimum.
Okay.
It used to be 10 acres or more is what you had to have to present a plan development. Once they took that out of the code, everybody went for a PD, because why not?
Yeah.
I mean, it's the same as a rezone. I would go for a PD as a developer over a rezone because I have more options.
Would you like us to put the minimum acreage or some minimum
I
acreage
don't
back
think
in?
that's going to be a step back for the developers. There's no way they'll go for it, so you're going to be right back in.
But
Now, this side's happy, but this side isn't. So.
But height has come up a number of times from you and from other people.
Yep.
We've tried to simplify the root ad stuff. We have not, in some cases, where it said you can go to X above, we've taken that out and said, nobody's said you can go that high. You're going to have to defend it to council, whichever you do. I think, given the concerns of height, we should do one of two things. We should get into the PUD standards and be more explicit about the showing you're going to have to make in order to get additional height, and I'm happy to do that. We could even, since height is such an issue, we could come up with a process that says if you are fine with your land uses and you're fine with your density, but you want more height, here's a process that you go through. It's not a PD. We're not going to get into negotiating everything about it, but here is a way that is a separate process, and my guess is you would like that to go to council, so it's a public process, but it could be more limited, so you're not just perpetuating the PUD. PUDs are...
Okay, I follow you. I can think of things as you're talking.
Maybe that's what we do. I think there are several ways to slay the height problem. So.
Okay. Yeah, the majority of reasons I believe the developers go through that process is the height and parking.
Okay.
They want to reduce the parking. So those are issues that it would be nice to get the input from the developers.
Okay.
And also from the people who, because the developers, if they don't have to provide any of it, that they're going to say, oh, that's the ultimate. But, realistically, you don't want your community not having parking provided by the developers for what they're building.
Yeah, I'm agreeing with your statement. I'm agreeing that we need to have adequate parking on site.
Okay.
And we should talk some more about with staff maybe. Our experience around the country is developers can't get financing without parking. So when they say they can't do it in Denver, they don't build without parking. They build with what you think is too little parking, but they can't get a loan. The guy's not going to loan on his building without adequate parking. So developers often say, my guess is that they're not going to build none. They're going to build as little as they need to get financing. But if anything, the banks are pretty conservative about this. The banks, they tell me, Don, you can lower my retail to 2 to 1,000. It doesn't matter. My bank says 3.5 to 1,000. So.
Oh, that's interesting. Okay. The other big issue I have is the land use and the zoning districts, that table 2.1. And my understanding was now that your recommendation was put it in the general plan.
The table, yeah.
I had a problem with that because to me then the voters are voting for what zoning is applicable to what land use, and they don't know zoning is not supposed to be in the general plan is what they've been told from day one. My understanding now is it's not going to go anywhere.
No.
You're not leaving it in the development code where it is currently?
My understanding was that the table of land use classifications was going to go into the plan, but not with the list of zone districts that were accompanying those land, because there are so many combinations of zone districts that could align
with
with
the table 2.1 that we currently have in our development code that says the land use is X and the appropriate zoning is Y.
I know, and
is there your plan to keep that where it currently is, or are you removing it?
Our plan is still to not put that table in the code.
And why is that? Because
I've never seen one. I've never seen one like that in the code. If you want to, I'm trying to figure out. Let's take it step by step. We adopt a code. The code says the following land use classifications from our plan translate into the following potential zone districts in our new code. We've already looked at the map of the general plan and the map of what's on the ground already, and trying not to make people non-conforming, trying not to say what you did before is illegal and we're changing it. I'm not sure what that does, because it could just as easily, your comment is, this way the citizens know that you shouldn't be asking for this zone district if you got that land use classification. With that land use classification, these are the only districts available to you. I understand that. In some cases, that land use classification lines up with some that are fairly low density and some that are medium density. So it could just as easily open up an argument by a citizen who wants to rezone from low to medium. Well, you really can't turn me down. It's part of the same land use classification. So you're worried that it's going to be used to, that without that classification tied to districts, people are going to be asking for districts that don't match the classification.
Correct.
And my worry is they could just as easily ask for a district that staff says, whoa, 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 whoa. That is, there were some areas of the city where that land use classification and that district line up. Yours was not one of them. And so it is not something that was intended to be generally available to anybody with that land use classification.
Yeah, but that would be a harder argument than the other way.
Okay.
My problem is you've given zoning administrator, and we went over this in an earlier meeting, versus director, and I have a big issue with the zoning administrator having that much power to make the decision, because now I think the comment made at the time was, well, it takes the politics out of it. Well, no, it doesn't, because that zoning administrator is under the city manager and then sometimes the director.
Well,
if he's told, find out how to do that in the code, he's now done it, and the only recourse of the public for an appeal is the Board of Adjustment. I don't like that. That's, to me, not right. And the politics is now happening behind the scenes instead of out in the public.
Well, they're two different issues. One is whether that table appears in the
Okay,
code.
and I will give you an example of that one. That one, there has been several times where staff presented the development to be able to be built, when in reality, because you could say that land use is not applicable, it's the wrong one, you have to go for a general plan amendment first. It stopped the process, and one was the catty corner from the high school. Okay. Nobody in that area is going to want a mini mart where you've got housing all around it.
I think you feel strongly that it ought to appear in the code.
I do.
You've made the point before, and I don't think we're going to settle it today.
Otherwise it's left up to the zoning administrator, and he's going to keep his own chart.
No, it's not set up to the zoning administrator. The rezoning is an inherently political process. So I'm agreeing with you, it doesn't take it out of that. The way it works in most cities is that staff and the zoning administrator staff look at the plan, and they look at the proposed rezoning, and they make a recommendation to planning board whether that matches or not, and they do that whether it's in the code or not. Right. And then planning board says yes, no, or maybe, and then it goes to council, and the same arguments are presented there. So I understand your argument is you don't think that process works very well because in your experience,
Well, there's too
staff
many,
has been willing to back things that the general plan should not have, won't
and there's been
support.
too many inconsistencies, and then it starts being the public thinking it's not about, it's about who the applicant is,
Yeah.
because they treat one person this way and one person the other way, and that's happened a lot in the past.
Well, you raise it, let's keep the issue separate. The issue of whether the table appears in the code, you've made good arguments for it. We'll go back and look at it again.
Okay.
I'm not personally persuaded. I think it's just as likely to bite you the wrong way. But I know you feel strongly about it, and that's all we can say is that you really
Well,
want
and
it
I'm
in there.
just basing it on the history and my,
I understand.
I mean, been on the commission 6 years, studied the zoning and all of that for several years.
Okay.
And I've seen it happen, and it does make you
Okay.
question.
Yeah. All right. So you just think the politics here require a stronger check
Yes.
on
Thank-
rezoning.
yeah,
But
that's a good
that's
way to-
different than the issue of zoning administrator, and I don't want to pour gas on a fire here, but we were asked to clarify the difference between director responsibilities and zoning administrator responsibilities.
Well, and I
This is
can,
not rezoning is not a zoning administrator decision. It isn't. Interpreting the code is a zoning administrator decision.
well, enforcement of the code according to statute is what the zoning administrator is
I
supposed to
understand.
do.
I understand.
This was an issue I brought up years ago when I was on the, and I have all the emails from that too. The problem was I felt because the title of zoning administrator was being used to sign almost every document that employee used, it started blurring the lines between what the director was doing and what the code says the director was doing. My hope was that more of the responsibilities would be that of the director because of the appeal process that's in place, and it keeps it open to the public to go through planning commission and the council, who is the ones that approve the code. Instead of saying it goes to zoning administrator makes his decision and throws it to the board of adjustment, who by the way can only talk to currently the zoning administrator. Nine times out of 10, they're going to back him because they can't even talk to anybody else.
Well, let's look at, if that's, I mean, that's one element of your, why you're uncomfortable. So let's take a look at who the Board of Adjustment can refer to. It is what we've proposed, well, what you have now
Right.
is a conflation of those two roles. If you wanted to leave them just as everything with the director, I suppose you could. We were asked earlier that was causing problems and that we ought to be clear about the difference. And I understand, you're right. Under Arizona law, it's enforcement of the zoning code. Most states interpret that you don't know how to enforce it unless you're the guy who needs to interpret it. And interpretations of law are not intended to be political. It is wrong to make the interpretation. If the code is being interpreted wrong, you amend the code.
I agree with you 100%, and I wish that's how it had gone all the years I've been involved. Unfortunately, it hasn't, therefore I'm gun shy on that.
So I think in both these cases, the table in the code and the authority that has been granted to the zoning administrator, I think, I won't put words in your mouth, you really feel the history of the city and the political culture here require a different approach than what
Yeah,
we've
I
put in
want
there.
it to be consistent. Like I told staff, I'd rather you be consistently wrong, because at least it shows you're doing it the same to everybody. It's when you start having the same exact situation and one guy's treated different than the other. That's when you have the problems and people in the city wondering all kinds of things.
Well, I have to say that the normal approach to that is to say, get your code straightened out with objective standards. Having interpretations of the code have a political path of appeal is just as likely or more likely to lead to favored applicants getting a weird interpretation than, who knows which way this is going to come.
I agree. Either way, it's political. One's just more in the public eye than the other.
That's true. That's true.
I mean, and I guess having one person having that power to decide all of that, I don't like it.
Yeah. Well,
I don't know.
I don't know what to say. If there are particular decisions, as a blanket statement, I don't think we're wrong. I think we're right to say the zoning administrator administers the zoning code. And that is by far the norm around the country. If you have particular decisions that you think are the things that are being manipulated in ways that you don't think are fair, let's look at those particular things. But as a blanket approach, because Lake Havasu City is Lake Havasu City, we shouldn't have the zoning administrator administering the zoning code. I don't agree with that. So.
Well, it's not so much administering the zoning code as the interpretations.
But that's,
and-
you can't administer it without interpreting it. Everybody who opens the code every day has to interpret what those codes mean. And it either, but I think your issue is, I think you'd be happy if Stu could interpret it, but it went to council for appeal.
Yeah,
It's not, it's the transparency or the participation in the discussion of the interpretation that
Yeah.
you'd like to, I understand
Sure.
your point.
okay, thank you. The change, and I don't remember which section of the code, but I didn't get to bring this up. There was, the state statutes have the minimum public notice. And I know when we were talking about it at one of the meetings, I didn't like that we were gonna change our code to be the minimum. Because most people, it takes that sign out on the property to even know what's going on, and that gets their attention to participate. If the only requirement is to put it in the paper, granted, I know the Stewart and staff said, oh, we're not gonna modify that, we'll continue to put it at the post office, we'll continue to put it on the property. Well, at any point in time, they can say, we decided not to, it takes too much work. I like having more notification.
I'm gonna amaze you by agreeing with you.
Oh, good.
No.
So
I actually agree with that. The intent, as you said, was not to change it.
Right.
Many codes do list more than the state minimums. So.
I think at a minimum, having the notice on the property is really important, because that's what gets people's attention. And trying to find them sometimes in the paper, and then it's the legal definition.
I think the general,
it's difficult.
And I think staff would agree with you. The question is whether we put it in the code or not. And you've made your point.
Okay.
It is the sign. The sign is, I think, by most people's, most studies I've seen have said the sign is the most effective. Although web-based notices are getting to be just as effective. So. Newspaper notices are not effective.
They're not. Okay. I guess I'm still having an issue with and I'll send you more of the specifics when I look through it.
Sure.
But it's looking like, again, it comes back to the zoning and what staff then is going to interpret if the table isn't in there. What if I have the X of a land use, what zoning districts are applicable? I mean, with this mixed use being put in as now you can use it everywhere.
Well, wait, that's not true. That's not true. There's a lot of the city that's zoned for residential, and there are most of the zone districts and most of the acreage in the city.
Besides the single family, we'll say RA, R2, R1. And you've changed them now.
R2 and R3 stay separate.
Where your R4 and R5 are, that's going to be the area where they could do a mixed use.
That's true. That's true.
R3.
No.
I'm not sure, but how does staff interpret it? Does he feel there's enough in there on the description in the general plan that, you know what, this zoning's pretty close, we'll let it go in?
R3 zoning is R3 zoning. They either have that use in the use table or they don't. There's no interpretation there. If that's, the mixed use part is not a discretionary action. It says you can do it or you can do it with approval. But it's not the zoning administrator's approval. It's either, I can't remember if it's Board of Adjustment or Planning Commission. It's not a zoning administrator decision.
Well, it's the zoning administrator that's going to decide.
He's going to read the table and he says, is there a C or a P? I don't, if he says there's a C, but there's not a C there.
Okay, I'll send you some examples and see what you say and what he says.
Okay, all right, I will. Sure.
Let's see. The bicycle parking. RUDAT brought in the live-work scenario, more density in an area, let's have your work environment and you live above it. I don't see Havasu really going in that direction, which is part of the reason I don't think the Main Street took either, because it required both of them.
But it doesn't require them now.
It doesn't require what?
Under the draft, you are allowed to do mixed use in Upper McCullough and Southgate and the Health District, but you're not required to.
You don't have to.
You don't have to. I would agree with you. That requirement often is enough to drive people away all by itself. So.
It doesn't work. So the bicycle parking, what is it, 10 to 50 requires you put in 4 bicycle parking, and it had dimensions. I would honestly pictured if you were required to put in the parking, it's the little metal things that go in. Yeah.
It's a rack.
So why do we have all the dimensions? Is that just?
I'd be happy to, if you want to take them out. as we write bicycle parking things in different cities, it's evolved to include those specifics. People,
Okay.
usually
And
there's a
maybe
bike.
they need a certain distance.
No, I'll tell you
I
very-
started picturing a lined thing with a pole or
No,
something going, are we
typical-
really?
I'd be happy to take the specifics out. I like the codes to be simpler. I think you're right about that, often we are faced with a bicycle lobby who wants that stuff in here. We
Okay.
have not had that in Lake Havasu. We can take some of the specifics out. I actually, when you say to a person, you're gonna have to put in 3 spaces, they say, well, racks come in 8. I'm gonna buy 8, so it
Right.
doesn't really matter at the lower end of the spectrum. I do think it is a better practice to do it, to have requirements. If you think they're too high, then we can cut 'em.
I think requiring every business in Havasu to provide for bikes, due to the topography of Havasu, you don't see a lot of people
Yeah.
riding the bikes. Usually it's the younger kids or people that exercise and they go over to the island,
Or out to the
Rotary Park, that area. So I could see in certain areas, maybe where your bike trails, you might have some of those, but
Would you like them limited just to the commercial and mixed-use zones?
I don't know. I'd have to really,
Okay.
I'd want to talk, I guess, to see what the development community thinks, because I don't think every store with 10 parking spaces really needs to put a bike rack out there.
Yeah, okay.
So I don't know, maybe I don't know if somebody
Well,
needs to
I
come up
mean,
with some different idea.
I use the concept of a bike rack. They come, usually it's 1 or 4 or 8. If you have 1, you're going to put in 1. So you're right.
Okay.
You might have to put in 2, but then you buy a rack for 4. This is a Lake Havasu thing. We'd be happy that they adjust, and I concede your point that fewer people are going to be riding in Lake Havasu than other places. We tried to take that into account in writing these. These are not off the shelf. We look at them.
Okay.
And I said to myself, the same thing. We need to put them in. The state law talks about bicycle circulation. It'd be
Right.
hard to explain why you didn't. The first thing you do for bicycle circulation is trails, and the second thing is bike parking. It'd be hard to explain how you had met the state law without some requirement. But I'm
Sure.
happy to look at them and say, are they too high, or should we just exempt some areas because they're just not going to ride there?
Right. Okay, yeah. So I don't have the answers to
Okay.
that one, but and I know the kids find some place to lock their bikes
That's
up.
true.
So,
True.
yeah, the PDs, I'll have to really look at that again, and
Okay.
that's not really for this meeting, so I don't want to get into a lot of specifics on that at this time. I don't know if you want to see if there's the public, and I'll go through some more of my notes. But you kind of touched base on a lot
Okay.
of them that I brought up to Stewart, so.
Well, I appreciate your thorough reading of it,
Thank
as
you.
always. Stu, do we want to do public comment on this? Do we have anybody on the phone? Do we have Mike?
Yes, I'm on the phone now.
Michael is our disembodied voice. Do you have any comments that you'd like to add?
Well, I've just been listening, and I've had a chance to go through some of it, not in as much detail, I have to say, as I had hoped by now, but I like the direction we're going. It seems like we've got a lot of... I missed the first part of the discussion. I'm sorry about that, but are we, when I look through the table, we're still missing a lot of the standards and details. When does that start to get interjected here?
Well, the draft that you have is complete in the sense that there are no missing sections. There are some blanks to be filled in, and there are drawings to be added, which we haven't had time to do the drawings for. And there are changes that were made in Module 2 that are going to require edits in Module 1, and the same thing for the comments I get on Module 3. So there are many, many corrections. But the short answer is that's the next draft. Somewhere in the fall, probably in September, we will give you what we are going to call a hearing draft, capital H, capital D, where we try to make it internally consistent and reflect the comments we've gotten in all 3 modules. So it's not only complete, but not only a full draft, but the gaps have been filled in and the inconsistencies and changes reflected.
Okay. So, for example, under each zoning district, the table related to the dimensional standards
Will be
obviously
jived.
those aren't.
Yes, will be filled in and jived. We have a dimensional table, but the way we do this, when we put those dummy tables in Module 1 or Module 2, We didn't have the numbers to put them in because we knew we'd have to work out the dimensions at this stage. So you're exactly right. When you get the next draft, in each of those districts, the numbers will be filled in, but they'll be filled in from the tables that we presented today.
Yeah, okay. I was just a little confused on how we went back and forth on that. So, okay, so for now, I'm just specifically
Well,
worried about
you can find the answers to all those tables by looking in this module 3, because the dimensional tables tell you what numbers are going to go in there.
Okay. I mean, I have a few things that I've been marking up and going through. It'd probably be easier since I'm not there to just put those comments or questions into an email if I could, that I could send to staff and to you guys to, look at and respond to. What are the next, I know there's a meeting tonight, and then what are the next, regarding Module 3 what are the next steps with that?
It would be helpful to me, to us, to Clarion, if we could get as many comments as we can by the end of July. That's not a deadline, but if we do it if you can make your way through it in a month and send your stuff in by then, we can be rewriting it. We just know that we have the majority of the comments by then, and we can start rolling them into what we're doing. What we do is go through all the comments we've gotten on all 3 modules, and there needs to be a date on which I can be pretty sure I've gotten them. So if you want to plug it in your mind as the end of July, then that would let me start working and making sure that I wasn't missing something in August. However, having said that, if people get comments in after that, we will obviously take them seriously and try to roll them in. It's just sometimes has to go back and replow the ground if it's a decision that's already been made and now you get a late comment. So.
Sure. Yeah, that's not a problem. I'm happy to get all my thoughts and comments in here over the next couple of weeks.
Okay, great. Is that it? For your end, you'll put them in writing and send them in to staff and circulate them to this group?
Yeah, I guess at the moment I'm just kind of glancing through my notes here. I guess carry on and I'll maybe interject in a minute.
Well, no, we can wait. That's fine. Well, I think the next step is probably to ask for public comment. So we can start that now, or we can wait until you go through your notes.
Go ahead and start the public comment process, and then I'll be here.
I have a question from Michael. What do you think on the bicycle parking?
I am a fan of promoting it. We are, we're not quite as much of an urban setting as most of when you're talking about a full bicycle program and making all of these commercial businesses require it. Laura, I agree with you to a point on that. I think encouraging it's a good thing. I don't know, a lot of times you'll see, and Clarion can probably speak to this, sometimes if you're providing bike parking and or other alternative parkings for golf carts or ATVs, sometimes it can be used as a credit or a reduction in your vehicular parking. I think it's a good thing in our community. Our community is, I feel, getting more active with the multi-use paths in the island and some other stuff that's planned, for down the road. I think we're going to see more and more. I know the road bike community has gotten more and more active in Havasu. The mountain bike community has gotten more and more active, as well as just, your general bicyclists. Topography is a constraint, but I think promoting it and, is a good thing. I'm just not quite sure how much we restrict or, require that they do X amount of bicycle parking. Mainly because our infrastructure in places might not make it hard.
Yeah.
You hate to see people strap bicycle racks on a tight sidewalk if there's not really room for it.
Well, maybe
they have to per code.
Maybe we cut the amounts, and as you say, I have written codes in which you get a credit against auto parking if you provide more than the required amount of bicycle parking. I've even written codes where the code says, don't come and ask for a variance from the parking requirement for autos until you've taken advantage of the clause that says first thing you do is provide more bicycle parking, and then because that automatically subtracts 1 or 2 spaces. So you do that, and
sure.
then if you need a variance beyond that, that's fine. But we're gonna decline to give you a variance when you haven't gone to the trouble of making it up in some other way. So.
Yeah, and I think we could probably promote it more or require it more in certain districts than just flat across the board. I don't think you're going to see the need for bicycles out, parts of town. But, in those core areas, Main Street, McCulloch, down along the channel, the island, the areas that tie into these sub-districts or districts and zoning districts that tie into the infrastructure that is there, the multi-use path along the highway and what ties into, the island pathway system. I think those areas are important to promote that because, but it's just how far we take it, I'm not 100% sure on at the moment.
Do you have a follow-up, Laura?
No, we pretty much agree then on that, and you can come up with suggestions, right?
We will. We will do it. I think the direction is pretty clear.
Okay, I do the RV hookup. I brought that one up, which I'm not sure if that's why you mentioned it, where it's removed completely. RA lots, some of those have had hookups put in because they're all an acre.
Okay.
So yeah, I have friends that actually come up and they hook up, and if you take that completely away, I don't own the RV.
I don't want to point fingers. I think that came from staff. So let me just talk I'm happy to exempt and say.
Well, I was trying to figure out why say, yeah, you can have it if you own it.
No,
I mean,
if
I own the RV, I can put one there and hook it up, but if I have a friend come up, I can't. So
there are lots of codes that say, well, if you own it, you need a place to park it. So in a place that's low density, like you guys have more people parking their own RVs on their own lots than any place I've ever seen.
Yeah. Well, if I owned it, it'd be in the RV garage, but if I have a friend coming up that, because we're having an event at our house or a gathering, we've got a hookup for it now, we basically are told we can't use it.
Well, I'm neutral on this one. Whatever you guys want to do is fine in terms of third-party RVs, either allowing them in some of the larger residential districts where there's plenty of property or otherwise.
Okay.
It is very common. Again, Lake Havasu is different. You're a resort destination. A lot of people drive RVs here, so an off-the-shelf thing won't work. But it's very common for codes to say, look, there's a big difference between parking your own toys on your own lot and turning your lot into an Airbnb where live in where people's mobile. We've had this come up more and more. Not only are you going to let people sleep on my couch, but can I just rent out my RV to people that want to do that? Yeah. And most cities are saying, no, that is a toy that you can park here. It was not intended to be a second dwelling unit.
Okay.
So.
I just thought the ownership thing kind of threw me as being a reason you can have it or not. I understand that at code enforcement, this is probably a big issue because there are people that park their RV in their front yard because they don't have any area to put it. But just kind of maybe relook at that.
Okay.
And I'll stop now. That one just came to me.
So, Michael, do you have other comments, or should we take public comment?
Go ahead into the public comments, and then I'll chime in.
I know there's at least one woman who likes to speak here. Is there? Yes, go ahead. I'm sorry. Could you? I don't have a remote mic. Could you come up? Okay, great. Thanks.
All right. First of all, I just want to thank you for all the hard work and the committee as well for all the hard work that they've done over the last several months. Just a couple observations. One on protection of residential. It appears that you've done a good job of protecting the residential neighborhoods. I keep hearing out there that it's going to be two-story buildings all over the place, which is clearly not the case. All right. When it comes to bicycle parking, quite honestly, I think that we have to consider that. We have ASU. What are we going to do when ASU is 2,500, 5,000 residents who like to use their bicycles? Are we going to say it's okay to park it on the street poles and the palm trees? Talk about a mess on your sidewalks. That's how you get one. Because then one guy puts it on the tree, and then they start stringing it along next to each other. So I really think that in certain areas that you have to think about bicycle parking. Not to mention the Metropolitan Planning Organization also has a mandate to consider multimodal type of transportation, and we have to deal with those things. And then the only other question was I saw something in there that for landscaping, that if there is a 25% expansion, they would have to follow the new land. What does that mean? What does that mean? 25% expansion of square footage? Really? So I could tear the place down?
No, that's new construction.
Oh, no, I'm going to leave up a wall. I would caution you that it should be some additional standard, whether it be 25% of reconstructing the building, or because when you just use one, there's too many ways to get around it. And I mean, because I would just leave up a wall.
Okay. You'd like to make it clear and tighten the language up.
Right.
Okay.
All right. Thanks.
No, that's helpful. Anybody else? Looks like the floor is yours.
And my name's Diane Klostermeyer, and looking at the proposals for the new zoning codes, how much attention did you give to the input from the residents as to height, density, and parking? In the surveys that went out, many of them were concerned about height, density, and to have adequate parking. Now we're talking about a reduction of anywhere up to 40, maybe even 50%. I think that's going to make it even more difficult for these people. We have some people who can't transverse very far. In other words, they'd have to park 2 or 3 blocks away in order to get to a business because you've limited the parking. As far as height, some people need to know what's going on next to their property or across the street. What is the change in the zoning code, and will you put the table in the code? You originally had it in the general plan, now that's been omitted, and now we have no table to go by, and I'm on the Board of Adjustment. I have to have some kind of guidelines to go by. Thank you very much. Any comments, sir?
I'm taking notes on your comments. I think you've reiterated the concern that Laura had about the fact that we not cut parking too much. We did look at survey results. I read them less strongly than you did, and I took it that we need to make sure we're not cutting parking below what Lake Havasu needs. But I also think that I was instructed to compare them with other cities that we think is similar, and so we are. It's not, I will not recommend that we go back to what we have now. Again, please tell me which uses. If it's retail, if it's bars, if it's restaurants, if it is particular uses, and those are the ones that have come up, and those are the normal ones, and maybe larger institutions. Those are the ones I'm going to look at, because those are the ones I'm going to look at first, because those are the ones where I think were reflected in the comments that we've heard so far. I want to be clear. We didn't apply a 40% to things. We compared them. I do not think it's a wise policy for Lake Havasu to just carry over its current parking requirements when you are requiring, in some cases, a significantly amount more for the very same use that other places don't. That's just a discouragement to investment in the city for no good reason. So I will look at them carefully. You've reiterated it. Heights, you've reiterated those comments too. I think we've done a good job of footnoting how the dimensional tables would change the existing heights. I will agree that it is hard to visualize how that would be, and I can talk to staff about, as we move down the road, and put a map out that kind of shows, well, if these districts were consolidated into the new name, where would that apply, and what would be the height limits in those areas? I think that would be easier for people to understand, and I think that's probably something we should do. It is, we have not tried to be, I would argue that what we've put on the table is easier to tell what the heights are than what you've got now, where you've got page after page after page after page of PUDs, and it might be this and it might be that, and depending upon this side of the block or that side of the block of this area of Mesquite, it could be a different number. I would argue that what you have now is not an easy thing to figure out heights, and in fact what we're proposing is going to be easier. But I think both you and Laura have raised the issue that you don't want you don't want people to be surprised by taller buildings than they expected to see, and that's the benchmark I'll do. And then you've both reiterated that you'd like to have the table back in the code. Just going to have to talk with staff about that. Once again, it's your project. It's your project. We haven't done it. I think my recommendation is still not to do it, but again, it's come up over and over and over again, and maybe it's something we want to reconsider. So, Are there any other comments? If not, can we, I think, Laura, you are the de facto chairman since you're here. Do you want to? Yeah, go ahead.
I'm going to run some hypotheticals.
Okay.
But I'm going to have to use what you originally had in the general plan as far as the land use and what applicable zoning districts applied.
Okay.
Because I guess what I see happening from the beginning was mixed use moving into the residential area, which was an intent because you talked about having some of the retail and within the neighborhoods.
Well,
correct?
There are two ways. As we just discussed a few minutes ago, I would have to re-look at the table. I think only in the highest multifamily district, R4, R5, which is being merged into RM, there are some non-residential uses. I got to tell you, there's very little R5, R4, R5 land. So that's, yes, there is a district, a proposed district that would have some mixed use in the residential area. But I'd have to go look because we were pretty limited on that. And the rest of them, R1, R2, I think, no mixed use. So that is not an accurate statement. When we talk about community convenience, you already have some of the lower C zones, CO, CR, that are not CR, CO, CN, that are supposed to be, they're not supposed to creep into the neighborhoods, but they're supposed to be a zone district where when you've got an intersection and it makes sense to do retail, you can do it. We have reconfigured that into the MUN, and I still think it is a good tool, but you're not going to wake up in the morning and have that happen. That's going to be a rezoning. Right.
No, and there are some areas where it transitions from a residential into like a commercial, and then you have like the drive-through with the gas station and the community, store, which people do like. You got to get a thing of milk. You don't have to run all the way into town.
Right.
But it's when is that appropriate and when it isn't. And I think sometimes it seems to be the rezones are done for other reasons, not for what's best for that neighborhood. And the more I guess I would have to see what are the R3, R4 properties.
Yeah.
Also, because once you start bringing the mixed use element in, now when the lot next to it wants to do something, I'm right next to, it makes rezone so much easier once you start slowly going in.
Well, let me take a look at what we've allowed in the RM, which is not much land, but we can look at it. If you want to take it out, we can. Again, you'd be criticized, some people will criticize you for putting any commercial into that district. As you know from apartment districts, other people will criticize you that, look, it's an apartment district.
Right.
Why can't I have a ground floor store so I don't have to stop on the way home? So
you're right. Yeah, totally. I just want to make sure that what I was seeing happening based on the zoning districts that were being allowed under certain land use categories, how much that seemed to change. Of course, if they're gone, most of my arguments go away because what ones are allowed? Then it comes back to
the table.
It all does. So right now I will base it on what you had and run some hypotheticals.
Oh, yeah.
And I'll bring those up. Okay, here's my concern and this is why.
Well, you have the draft of, Darcy and I went over a couple times with staff that table. The table is not changing. Our disagreement is whether it belongs in the code or not. And you and others have been very strongly advocating that it does. But when you run your hypotheticals, you can use that table. No one's suggested a different table than that.
Okay, and that's what I'll do, because when I first looked at that, the concern with the height and the density seemed to stretch into areas that you didn't have it before.
Okay.
So,
all right.
And that's pretty much it. I will make sure I have all those to you before July, and I'm finished.
That'd be great. That'd be great.
If I'm saying we're done, you can follow up, finish, and we'll be done.
We're done. Thank you all for coming, and there is another meeting at 6 o'clock, so thank you for being loyal and showing up. Thanks.
Hey, if I may, guys, I'd like to interject one thing just quickly. I wanted to compliment you on the additions to the landscape code and the regulations and trying to set a policy there. To me, obviously, those of you who know me would know I would probably be looking closely at this, but to date, there's been, I feel, a lack of, we've always had a landscape requirement of, 10, 20%, but there was no detail to that requirement. And so often the landscape requirement was met with solely rock and a planter. And to me, that's not in the best interest of the visual beauty of Lake Havasu. And I like a lot of what you put in there. There's a few things I'll provide some comments on that could maybe make, the regulations related to that a little bit better, but I wanted to thank you for your effort in applying some better standards to what ultimately beautifies all of the development as it does happen throughout town.
Thank you. All right, I think we're adjourned.